Welcome back, everybody. In this final lesson exploring the doctrine of notice, we're going to explore the idea of something known as imputed notice. Now, this is the third and final of the three major methods by which notice of an equitable interest may exist, or maybe be able to notify that individual who is looking to purchase unregistered title. And ultimately, this is the final kind of notice which exists, and it sits alongside the idea relating to actual notice, as well as the idea of constructive notice. So we know already, as a sort of basic recap, that actual notice infers the ability for an individual to actually have notice of the equitable interest at the point at which they are looking to purchase said property. The idea of constructive notice is this idea that you should carry out the relevant checks that an individual who is looking to purchase property should do in order to try and find equitable interests where actual notice doesn't necessarily reveal itself. The idea of imputed notice essentially exists owing to the reality and the practical realities and the practical considerations that relate to the reality of title purchasing, of conveyancing. The reason why is because in reality, it is often not necessarily the purchaser who makes full inspections, whether this be inspections of the physical property or of the legal title, and they don't make and find the evidence of equitable interest either. This is not a burden that is necessarily placed on the purchaser of the estate. It is actually a burden which is placed by and on the representatives of the purchaser. So when you buy a house, when you purchase an estate, there will be a lot of legal and logistical issues that have to be ironed out. And for the most part, most individuals who live in society aren't lawyers and don't understand land law, because why would you want to unless you want to be a lawyer? And so the result of which is you will have representatives, you'll have solicitors who will be the ones who make the relevant checks, the relevant inspections, the relevant inspections of the deeds and looking at the title itself, and all of which comes together to ultimately represent a type of notice which exists, which places a burden on the representatives of the purchaser. And so that's what imputed notice essentially does. It means that if a representative of the purchaser has been given actual or constructive notice as a representative of the purchaser, then this is also bound to the purchaser themselves. So this ultimately places a burden on the representative, a burden on the solicitor, for example, but it also places something of a burden on the purchaser. The purchaser has to be able to communicate with the solicitor or any other representative who is given the actual or constructive notice to make sure that they know of any kind of equitable interest that may exist over the property. Now, Section 199 of the Law of Property Act says the following. They say that a purchaser shall not be prejudicially affected by notice of any instrument or matter capable of registration under the provisions of the Land Charges Act 1925, or any enactment which replaces which is void or not enforceable as against him under that act or enactment by reason of non-registration thereof, any other instrument or matter of fact or thing, unless it is within his own knowledge or would have come to his knowledge if such inquiries and inspections had been made as ought reasonably have been made by him, or in the same transaction with respect to which a question of notice to a purchaser arises, it has come to the knowledge of his counsel as such, or of his solicitor or other agent as such, or would have come to the knowledge of his solicitor or other agent as such, if such inquiries and inspections had been made as ought reasonably to have been made by the solicitor or other agent. So, a couple of things to note here. Drink every time you hear the word as such in reading this provision. But secondly, Part A talks about actual and constructive notice. Okay, so actual notice is within his own knowledge. That part of it is the actual notice. If it is within your knowledge at the time of purchase, then you have been given actual notice. Constructive notice is represented in the second part of Section 1II, which is, or would have come to his knowledge if such inquiries and inspections had been made as ought reasonably to have been made by him. So that's constructive notice. There is a burden on the purchaser to make inquiries and inspections which ought to have reasonably been made in the process of purchasing title. That is constructive notice. Part B then talks about imputed notice, talking about in the exact same transaction, if the notice to the purchaser arises but hasn't come to the knowledge of the purchaser themselves directly, but has come to the knowledge of his counsel or of his solicitor or other agents, and then talks about how actual and constructive notice can apply to that of the representatives of the purchaser. So the rationale for imputed notice should be quite easy to understand, really, because given the fact that for the most part, especially today, the purchase of title is done through individuals acting as agents on behalf of said purchaser, the idea that notice may be negated because it was not the purchasers themselves who received it would essentially open the door for an individual to reject as many equitable rights as they so choose. Because that's a solid foolproof defense to the doctrine of notice if imputed notice doesn't exist. If you could just say, well, my agent was the person, or my solicitor or my counsel was the person who did all these things as is allowed, and so as a result of which I was not given any notice, therefore I am not bound by any equitable interest. That would be a particularly easy way of negating any equitable interests. So what imputed notice does is essentially create the same burden, but for the representatives. Now, I want to finish with a case to explain this in a little bit more detail. This is the case from 1986, and this is the Kingsworth Finance and Tizard case. Ultimately, this is the case which involves a married couple who go to purchase a property, and this property is intended to be the matrimonial home. Matrimonial home, essentially the property that the family lives under, the man and the wife, the married couple. They had both contributed to the purchase price, but only the husband was the legal owner of the title. Now, for those of you who have either studied equity and trusts already, or have gone through some of our lessons on equity and trust that we have done, you may understand what the resulting issue that arises appears to be in this case. When you have two individuals that contribute significantly to the purchase price of a property, but only one is given the legal owner of the title, then what it means is the other individual has an implied trust which results from the fact that they had contributed to the purchase price. When the marriage broke down, the wife moved out of the home, but made regular visits on a daily basis to look after the children, so she was around for quite a lot of the time. Now, the husband then went on to mortgage the property. Now, what he had done was falsely claim that he had been single, and he invited an inspector to perform the relevant checks on the property. Now, the inspector found no evidence of the interests or the occupation of the wife, the fact that the wife was still around and regularly looking after the children on a regular basis. Don't forget, the wife has an equitable interest now because the wife contributed to the purchase price, and so under resulting trust has an interest in this property. So the fact that the husband went on to mortgage the property meant that there was this issue of whether or not he is bound by the wife's equitable interest under the doctrine of notice. Now, the inspector, like we've said, found no evidence of the interest of the occupation. Now, ultimately, the beneficial interest that the wife had, of course, is a constructive trust on account of the substantial contribution to the purchase price. And so, as a result of which, this would serve the defendant on the basis of the doctrine of notice. So, given the fact that there were inconsistencies as well between the inspector of the title and that there was the failure to acquire certain reasonable steps, ultimately all of this falls under the principle of constructive notice, but it is done imputedly, essentially. It is imputed by the fact that it was done not by the husband themselves, the actual person or the purchaser of the mortgage, but it was done by an inspector to make very, very clear to try and make clear any kind of potential interest that could exist. And so as a result of which you have not only constructive notice, but you also have imputed notice on account of the fact that this was done through a third party, through an inspector.